on September 24, 2011, as part of its examination of the rule of law in times of terrorism, the section of litigation interviewed Michael Mukasey, the former Attorney General of the United States.
So I wanted to start with the ultimate question in a way, and maybe then work backward and talk about some of your reasons. Where do you think terrorism suspects should be tried in this day and age? And if it's not in an existing format, what should it look like?
Okay. That depends, I guess, in part on where they're caught and under what circumstances. We now have a binary choice. It's either military commissions or Article III courts. I'm not convinced that that's necessarily optimal. We may, long-term, need a national security court, which would combine some features of both.
Well, talk to us a little bit about what kinds of people you think might best be tried in national security courts, and what kinds of people might best be tried in one of the two binary choices we have right now.
Okay, I think the kinds of people who might best be tried before national security courts are the people who will now be tried before military commissions. I don't think that the military, we've had military commissions throughout our history, from the Revolution through and including World War II, but I don't think the military is ideally suited to run a parallel justice system. That's not what they're in the business of doing. They're in the business of winning wars, and you do that principally by killing people and blowing stuff up, which is, it's very important that they do that they do it well.
Correct.
But running a parallel justice system isn't really part of that, and they can do it on an ad hoc basis. They've done it on an ad hoc basis, but doing it long term, I think, diminishes their edge. They don't have just to take the most mundane thing, there's no real promotion track for somebody who was involved long term in this kind of thing.